Most of the state exams, for both agents and adjusters, include a section of questions on contract law. This is because an insurance policy is a contract. A contract can be defined as an agreement between two or more parties that is enforceable by law. A contract is created when the parties to a contract have established all the elements required to make it enforceable. If necessary, the courts will enforce the terms of a contract. For a contract to be considered valid by a court of law, there must be intent on the part of all parties to enter into a legal relationship. This is an important concept to remember for your state exam. A contract is not valid if even one of the parties to the contract did not intend to for a contractual relationship with the other party. Additionally, a valid contract must possess the following four elements: a capacity to contract, a legal purpose, an offer and acceptance, and a consideration. We will discuss these four elements on the next few screens of the course. The first element of a valid contract is the capacity to contract. This is also referred to as competent parties. In order for the contract to be binding, all parties must have the necessary capacity to enter into the contract. Cases where capacity has been deemed insufficient include people under the age of 18 and mentally incompetent individuals. Also, those who sign a contract while under the influence of drugs or alcohol are not considered to have the capacity to contract. An exception to this would be a minor, ages 15 to 18, are permitted to enter into contract for life insurance. For a contract to be valid, it must be entered into for a legal purpose. An insurance contract must not be written to cover an illegal activity. Any contract that is entered into for an illegal purpose will not be considered legally binding in a course of law. For a contract to be valid, an offer must be made by one party, and that offer must be accepted by another party. With insurance, the applicant makes an offer by completing the application. The insurance company, after review of the application, can accept the offer and issue a policy. A consideration is something that has value in the eyes of the law. In insurance, the consideration is the premium that the insured pays in exchange for the insurance company's promise to pay the future if a loss occurs. Remember the term consideration. It has confused some students in the past because when they read the word consideration in an exam question, they thought it meant that the applicant was giving careful consideration to whether or not they should purchase the policy. Again, when we use the term consideration, when discussing insurance, we are referring to the premium. A mnemonic device is a technique that anyone can use to improve their ability to remember information. When mnemonic devices are appropriate, we will use them throughout this course. To assist you in remembering the elements of a valid contract, we will use the mnemonic device. CLOC clock. C. Capacity to contract or competent parties. L. Legal purpose. O. Offer and acceptance. And C. Consideration. It is important to understand the parties to an insurance contract. The first party on an insurance contract is the insured. Insurance claims submitted by the insured to her own insurance company are called first-party claims. For example, if an insured suffers damage to the roof of her home, she will submit a first-party claim to her insurance company for the loss. The second party is, of course, the insurance company. The third party on an insurance contract is the party that has been damaged by the first party. Third-party claims are liability insurance claims. For example, if a third party was injured at the home of the first party, the liability section of the insured's homeowner's policy would cover the claim made by the third party. Next, we will review the parts of the insurance contract. This is very important information for you to remember, as you will need to understand what each of these sections include as we move into studying specific insurance policies. All insurance policies are divided into four general sections, and you will see several questions on your state licensing exam that asks what information can be found in each of these sections. You can remember the names of the four general sections using the acronym DICE. This stands for Declarations, Insuring Agreement, Conditions, and Exclusions. The first section is the Declarations page, sometimes called the Information page. The information included on the Declarations page answers the who, what, where, when questions of an insurance policy. It contains the name and address of the insured or policy owner, the policy term or period, the policy limit of liability, the premium amount, and any deductibles. That may apply. If it is a property insurance policy, the declarations page will include a description of the property. If it is a life insurance policy, the name of the person whose life is being insured is also listed on this page. The insuring agreement establishes and defines what is covered under the policy, the risks assumed, and the nature of the coverage. This is the section of the policy where the contractual agreement is located. This agreement is the insurance company's promise to pay. It is very likely you will encounter a question on your state licensing exam that refers to the insurance company's promise to pay. When you see this phrase, you will know the question is referring to the insuring agreement section of the policy. The insurance company's promise to pay includes payments to either the insured or a payment to a third party on behalf of the insured. For example, a policy that covers property will make payments to the insured for losses to their covered property. With a health insurance policy, the company makes a promise to pay a third party. In the case of health insurance, the third party includes a physician or other health care practitioners that provide treatment services. With the liability section of an automobile policy, the insurance company promises to pay a third party who was injured by the insured. The insuring agreement will list the coverages in a broad fashion. For example, a workers' compensation policy may state that workers are covered for all injuries arising out of and in the course of the employment. This is a broad definition of coverage that is later narrowed down by the exclusion and definition sections. The exclusion for worker-related injury that occurred while the injured worker was intoxicated on the job is an example of how the coverage is narrowed. You will see several questions on your state exam regarding the conditions and exclusion sections of specific policy types. The conditions section contains the duties of the insured and the insurer in case of a loss, including the instructions for submitting a proof of loss. Other conditions listed are the parameters for providing a loss notice, how other insurance is handled, subrogation rights, cancellation and non-renewal provisions, and many other specifications, depending on the policy type. Any changes that are made to the policy provisions are listed here as well. The exclusion section defines what the insurance policy will not cover. Specifically, listing exclusions in the contract eliminates duplication and coverage, assists in managing moral hazards, and allows for lower premiums. For example, a policy may exclude coverage for a specific item from one section of the policy because it is already covered in another section of the same policy. Exclusions for intentional acts and breach of duty can prevent an insurance company from covering moral hazards that resulted in losses that could have been prevented by the insured. And insurance companies may exclude coverage for risks that would be so expensive for the insurer to cover that is may cause the insurer to become insolvent or require them to raise premium rates to prohibitive levels. There are 7 characteristics of an insurance contract that the state exam content outlines. Cover. First, we must understand that an insurance contract is an aleatory contract. This means that the contract is contingent upon uncertain or random events, and that it provides an unequal transfer between the parties. For example, insurance who pay a premium for years, but never have the need to submit a claim, are paying for coverage they never receive. In this instance, the contract is unequal in favor of the insurance company. However, there are insurants who have only been paying a premium for a short period of time before they submit a claim for a very expensive loss. In this example, the contract is unequal in favor of the insured. Insurance policies are contracts of adhesion. This is a contract between two parties, where one party sets the terms and conditions of the contract, leaving the other party in a ticket or leave a position. Because the insurance company sets the policy language, leaving the insured design onto the policy language or not have coverage, courts of law will usually rule in favor of the insured when policy language is deemed to be ambiguous. Policies are also executive contracts, meaning that both parties to the contract must perform their required duties before the contract will be fully executed. Therefore, if the conditions section of the policy states that the insured has the duty to submit a properly completed proof of loss statement, then the policy will not be fully executed until that statement is submitted. We've alluded to this already, but an insurance policy is a conditional contract. This means that the insurance company will pay the claims they owe if the conditions specified in the policy are met. Insurance policies are also unilateral contracts. This is because only one party to the contract is legally bound to perform its part of the agreement. If the insured does not pay the premium, the policy will simply be canceled. The insurance company cannot sue the insured for not paying the premium. However, if the insured pays the premium and the insurance company does not perform its duties as specified in the contract, the insured can sue the insurance company. Insurance policies are personal contracts because the personal insurable interest of the first named insured is the basis for the coverage, and the final characteristic is that insurance policies are contracts of indemnification. As we have discussed previously, insurance contracts will only restore the insured to the financial position she previously held before the loss. There are two broad principles that form the legal foundation of all insurance policies. The first one is the doctrine of utmost good faith. This means that when formulating the insurance contract, both parties must be able to rely on the other to be honest and trustworthy. For example, an insurance agent deliberately does not explain all of the policy provisions to the applicant for insurance. The provisions he failed to explain include additional premium charges. The agent does not explain these provisions, thinking that the insured will pay the premium without question, and he, the agent, will receive a higher commission on the policy. This act violates the doctrine of utmost good faith because the insured expected the agent to be honest when explaining the policy provisions. The doctrine of reasonable expectations states that an insurance policy should provide coverage to the extent that the average policyholder would expect. However, this is not always straightforward. For example, in recent years, many people who purchased homeowners insurance expected that they would be covered for flood, but flood is specifically excluded. Therefore, if the insured had a loss for flood, she could take the insurer to court, citing the doctrine of reasonable expectations. The insured may not win the case. Because the policy is explicit in excluding flood, this doctrine could still be used as the basis for a lawsuit. Statements made by an applicant for an insurance policy that are guaranteed to be true are known as warranties. If a warranty is later found to be untrue, it will avoid the policy. A breach of warranty is a failure of the insured to comply with one or more of the policy conditions. For example, an individual purchases a health insurance policy at a preferred rate because she does not smoke. However, after the policy is in force, she begins smoking. This would be a breach of warranty. A breach of warranty may or may not void the policy, depending on whether or not the breach is material to the risk and the requirements of the policy provisions. Representations are statements made on an application for insurance that are true to the applicant's best knowledge and belief. If a representation is later found to be untrue, it will not void the policy. Representations can best be described as misremembering or making a mistake. For example, a woman is applying for auto insurance on two cars owned by her and her husband. When asked if there have been any speeding tickets or other moving violations in the past 3 years, the woman answers no. Later in the underwriting process, the insurer finds that the woman's husband received 2 speeding citations in the past year. The woman did not know about her husband's speeding tickets, therefore, she did not make a statement that was knowingly false. So she is not at fault for a misrepresentation. Misrepresentations are statements made by an applicant for insurance or by the agent or producer selling the policy that are known to be false. The applicant may misrepresent the number of moving violations he has received in order to receive a lower auto insurance rate. The agent or producer may misrepresent the policy provisions, the coverage, or the premium rates in order to sell a policy. All of these examples are material misrepresentations because, in the case of the insured, the company may not have issued the auto insurance policy had they known about the moving violations. The misrepresentations made by the agent or producer are also material because had the insured known the truth about the provisions, coverages, or premium amount, he may not have purchased the policy. Additionally, the agent may be subject to other penalties for committing an unfair trade practice. There are some specific types of misrepresentations that may be illegally used by an insurance agent or producer. These misrepresentations are covered on the exam content outlines, not only for agents, but also adjusters. Twisting occurs when an agent uses misrepresentations in an attempt to convince an insured to replace an existing policy purchased from one insurance carrier with a new policy from a different insurance carrier, a carrier that the agent represents. Churning occurs when an agent uses misrepresentations to convince an insured to replace a policy that exists with the agent's carrier with another, more expensive policy with that same carrier. Replacing a policy is not illegal, but using misrepresentations to convince the client to replace the policy is illegal. If misrepresentations are lies, sliding is a lie of omission. An insurance agent or producer is sliding if they do not disclose all the products and services included in a policy that increase the premium in order to earn a higher commission for themselves. Concealment. Concealment is the failure of the insured to reveal known material facts. When applying for insurance, material facts are those that have the insurer known them before the policy was issued. They would not have insured the risk. So you will probably see a question on your state exam where you need to differentiate between a misrepresentation and concealment. There is an easy way to remember. A misrepresentation is a lie. Concealment means to hide. Fraud is an intentional act designed to deceive and induce another person to part with something of value. Some state laws provide different penalties for soft fraud versus hard fraud. Soft fraud is unplanned and occurs when the insured has the opportunity to exaggerate a legitimate claim to obtain a higher settlement amount. Hard fraud is a premeditated plan to deliberately create a claim to obtain a settlement. When an insurance claim is being litigated in a court of law, the doctrines of waiver in estoppel are given way when making decisions. A waiver is the intentional relinquishment of known right. Intentional conduct that is inconsistent with claiming a known right can also be interpreted as a waiver. For example, an insured who fails to file a claim within the time frame required by the policy provisions and state law could have her behavior interpreted as a waiver of her right to file a claim. There are two types of waivers: express waivers and implied waivers. An express waiver is one that is expressly stated. For example, the insurer has the right to have an autopsy performed on the decedent when a claim is made under a life insurance policy. The insurer can expressly state to the decedent's beneficiaries that they are waiving their right to autopsy. Using this same example, the insurance company may simply pay the claim without performing an autopsy. By paying the claim, the insurance company has implied that it waived its right to autopsy. Estoppel is a legal doctrine that prevents or stops a party from contradicting its own previous actions if those actions have reasonably been or relied upon by another party. For example, most insurance policies include a provision that allows it to be canceled for non-payment of premium. If an insurance company has continuously permitted an insurer to submit extremely late premium payments without canceling the policy, later they could be stopped from canceling the policy due to non-payment of premium. It could be argued that the insured was led to believe that late payments were acceptable because the insurance company had allowed it several times before.